and then Senator back. Senator Madigan.
Thank you, Chair. Thank you, Minister. Mr McDevitt, my questions pertain to the AFL Doping Tribunal and the 34 Essendon footballers. Is it correct that the AFL Doping Tribunal cleared the 34 Essendon footballers of an alleged violation of the AFL Doping Code?
Yes, Senator, that's correct.
Okay. And was the AFL Doping Tribunal chaired by two retired Victorian County Court judges and an eminent barrister?
That's correct, Senator.
Right. Now, Mr McDevitt, did ASADA believe there was something fundamentally wrong with that decision of those two retired Victorian County Court judges and eminent barrister who actually convict and send people to jail in their professions previously?
Senator, I might just make some opening comments, and the first one is to say that at no time have I questioned the integrity of the individuals who sit on the AFL Anti-Doping Tribunal. These are people of great integrity and great experience. As you yourself pointed out, their experience basically emanates from the criminal jurisdiction, which is a jurisdiction which looks at issues generally through the lens of beyond a reasonable doubt. I believe, and WADA believed, that in this case the AFL Tribunal simply got it wrong. Okay. And I believe that for several reasons. One is that I do not believe that due weighting was given to pieces of evidence that were presented to that trial, to that tribunal. And secondly, I believe that they held the bar of comfortable satisfaction so high that it would have set, if allowed to remain, it would have set a precedent which would have made it extremely difficult, if not impossible, not only for ASADA, but for any anti-doping organisation in the world to successfully prosecute a matter which did not, as in this case, involve a positive test. And Senator, let me just give you a couple of examples. And as you know, I fully supported the WADA appeal, and I supported it in kind and financially. The decision to appeal was totally WADA's. Don't overestimate my influence on WADA. They actually undertook their own reviews and made their own decisions to appeal. But let me just give you a couple of examples. Why the tribunal itself accepted that Stephen Dank made plans to use thymosin beta-4 as part of Essendon's injection program. They also accepted that the players had consented to being injected with thymosin and that injections had occurred. Despite this, they were not comfortably concerned or satisfied that the injections actually contained thymosin beta-4 because there were no adequate records kept and because Essendon failed to carry out lab analysis of the substances. So when you look at a couple of these issues, the CAS panel openly disagreed with the tribunal on several things. Let's talk about the records. They said no record. Well, Senator, you asked the question.
Just for clarity there, Mr McDevitt, CAS is not an Australian body, is it? Just for everybody to be crystal clear here.
CAS is the ultimate sports...
It's not an Australian court, Mr McDevitt, is it? It's not Australian law.
Well,
it's not Australian law, is it, Mr McDevitt?
It is.
It's not subject to review by the Australian Parliament, Australian politicians, which most Australians expect and, more importantly, deserve, Mr McDevitt, is it? It is not an Australian court.
I disagree with you,
It is a foreign body. It's not a court.
Senator.
Let's be crystal clear, Mr McDevitt.
Senator, we have a legislative framework
It's not an Australian court, is it, Mr McDevitt? It's not to Australian law.
Senator Madigan, you've put that a number of times.
Well, he won't answer the question.
Senator Madigan.
People out.
Senator Madigan, just one moment. Right, I'm giving you a fair go, but you've put that several times. Mr McDevitt can come back and answer, and if you're not satisfied with the answer, you can ask him further questions, but I won't have you badgering him. So I'll go to Mr McDevitt.
Senator, can I finish the original question, which was about the fact that the decision was so fundamentally flawed? The Court of Arbitration for Sport, and I was talking about the lack of records. For example, they said no records were kept within Essendon. Indeed, the absence of such records was the subject of forceful criticism by the AFL Tribunal and relied upon it as a reason to find ASADA's case to be insufficiently substantiated. Now, the CAS, in looking at the lack of records, actually said, however, the very fact that no record was kept is, in the panel's view, suggestive again of a desire to shroud the regime in a veil of secrecy. Secondly, talking about the source of the substance itself. Again, the CAS panel found, in their view, that the AFL Tribunal had got it wrong and said it is not an essential link or indeed a strand in a case of a violation of the code that the source of the product used can be identified. It has never been so stated in any of the relevant case law, is not required on the face of the article itself or the commentary, and would be a significant bar against the fight against doping. And Senator, that is why I forego my opportunity to appeal within the AFL framework. I was extremely confident that WADA would appeal this finding because it was simply untenable.
So when you earlier said in your evidence, Mr McDevitt, that WADA appealed, so WADA didn't appeal. Why did ASADA, if you weren't happy with the decision, you've said that the decision was flawed, why did ASADA not avail itself of the appeals process afforded to it under the AFL Doping Tribunal, which is an Australian body, not a foreign body?
Well, Senator, there were a couple of reasons for that, and you may recall that the day after the tribunal released its decision, I did a press conference, and one of the very first things I said was an appeal option is a very, very live option. The appeal option had two possible routes for me. One was to appeal to the AFL Anti-Doping Appeals Tribunal, which would mean that the matters would remain under the umbrella of the AFL's framework. And the second option, which was the one I took, was to forego my appeal option and refer the matters to WADA and allow them then, if they saw fit, to initiate an appeal to CAS. I did not have a direct opportunity to appeal to CAS. Senator, quite frankly, this matter was going to end up in CAS anyway. It would have cost the Australian taxpayer approximately $1 million for me to have run fully an appeal, because the appeals tribunal would have wanted a full de novo hearing, which would have meant we would have run the whole case again before that appeals tribunal. I can almost guarantee you that if the result of that appeals tribunal had been the players being found guilty, then they would have almost certainly themselves exercised their appeal option, which was open to them, to then go to the CAS. I can tell you also that if the appeals tribunal had found in favour of the players and applied and accepted the same logic of the lower tribunal in the original decision, then for the exact same reasons I've just outlined to you, I would have then initiated my right of appeal to CAS. I believe we saved almost $1 million, and we also saved almost 12 months in this process by opting for the option which I did, and that is why I decided not to appeal within the AFL framework.
Well, Mr McDevitt, given that the Commonwealth, through ASADA, contributed more than, I think it was around $100,000 towards the cost of the WADA case against ASADA, and you're saying, just in your evidence there, that it would have cost somewhere in the vicinity of $1 million. So you're saying there's a price on justice for people, for these 34 individuals, their wives, partners and their children. Is that what you're putting to us? That
No, I'm not, Senator.
Well, you just said we could have spent $1 million, or we could have spent $100,000. That the money's the consideration, not justice for people. That we put a price on justice.
I think you're putting words in my mouth, Senator, with all due respect. I said there was a saving in funding, in taxpayers' money, which I think is a reasonable and fair consideration. I think there was a significant saving in time. We would be before CAS now if we had gone the route that you are saying we probably should have. We probably should have gone.
Not an Australian.
So we saved money. We saved a hell of a lot of time. Look, I'm aware of the stress that these matters have caused for all stakeholders involved here, not just the players. And I think it was a considerable saving there. What we needed was resolution of these matters. And, Senator, we needed the truth to be revealed.
Mr McDevitt, do you believe that ASADA, as a Commonwealth agency, has an obligation to act as a model litigant?
Absolutely, Senator, and we do at all times act as a model litigant.
Right, so in Section D of the Commonwealth's obligation to act as a model litigant, it says, endeavouring to avoid, prevent and limit the scope of legal proceedings wherever possible, including by giving consideration all cases to alternative dispute resolution before initiating legal proceedings and participating in alternative dispute resolution processes where appropriate. And I go back to the fact that you did have an ability, there was an opportunity there for ASADA to appeal the decision under the AFL Doping Tribunal procedures, but you didn't take it. And that's on Australian soil, under Australian law, not a foreign body. So now we've got a situation, and you've said that, the 34 players, they can appeal the decision to CAS, but it's across the other side of the world, Mr McDevitt, and these people's livelihood has been taken from them. And, how do you think it's fair that they have to go to the other side of the world? And I think the hearings are in French, aren't they, Mr McDevitt, in CAS?
Well, Senator,
do you think that's fair?
There's multiple questions. Absolutely, Senator. I think the main thing we've got to do with these matters is get to the truth. We need to expose the facts. Now, I don't think you should be talking about the Court of Arbitration for Sport as if it's some foreign entity that is unknown to us. The Court of Arbitration for Sport hears about 300 matters a year. It has 3 offices, one in Lausanne, one in New York and one right here in Sydney. It is the most eminent body. It is recognised for all 85 sports that we deal with in this country. An appeal option to the Court of Arbitration for Sport is built in fairness to athletes to have an appeal option beyond their own tribunals. Are you saying, Senator, in terms of fairness, that you think that appeal option should be taken away from athletes? Because they exercise it quite regularly.
I want them to have an appeal, Mr McDevitt. I want them to have an appeal under Australian law, which Australians expect and most importantly deserve, not to be trialled by some foreign body. The game of AFL, Mr McDevitt, is not an international sport, it's an Indigenous sport to Australia. Now, Australians expect, and as I repeat again, deserve to be trialled under Australian law. And I think, Mr McDevitt, that there are people quite capable of trialling people for alleged breaches of codes in this country and not for it to be outsourced to a foreign body. ASADA did have an opportunity to avail themselves of an appeals process and they didn't do it. You then outsourced it, and some might say you went verdict shopping for a verdict to a foreign body.
Well, Senator, I totally disagree with what you were saying there.
I'm sure you would.
We acted entirely as a model litigant would act, and we took the option of going to the Court of Arbitration for Sport. In the last couple of years, we've had 11 matters before the Court of Arbitration for Sport, not just this one. As I said, it adjudicates on over 300 matters a year, including multiple Australian matters. There are 23 Australians who are arbitrators on the Court of Arbitration for Sport. It is a body which is totally independent of sports, which I think is absolutely critical and is the way that we should globally be. And in fact, as you'll see today, the International Olympic Committee has now said any matters which come out of, any anti-doping matters which come out of this year's Olympics or any further Olympics will be immediately referred to the Court of Arbitration for Sport, a totally independent body of eminent experts in sports law.
Mr McDevitt, is there a distinct difference in ASADA's view between an amateur sports person and a professional sports person? Do you see any difference there?
No, Senator. I believe they all have. They all should have the rights to appeal any matters that are against them, and one of those critical rights for them is to have an appeal option to the Court of Arbitration for Sport.
Okay. And
Senator, there is this fallacy out there that it doesn't apply, for example, to team sports. Of the sports that we have here in Australia, there are, of the 85 sports, we have 30 plus of them have a team element, and 18 of them are pure team sports. They, includes rugby union, hockey, ice hockey, AFL, soccer. There's 18 sports that are just pure. It's good enough for the English Premier League, Senator, but it's not good enough for the AFL to actually have an option to go to the Court of Arbitration for Sport.
But Mr McDevitt, do Australians have a right to be tried, examined for whatever they may or may not have done under Australian law?
Senator, let me put it another way. What was conducted here and the processes that were followed here were under the AFL's anti-doping policy. So under the AFL's own rules, we exercised the options to appeal to CAS under their rules. Does that help you?
Mr McDevitt, but earlier in your evidence you said that, for want of better words, the burden of proof to those two retired Victorian County Court judges, an eminent barrister was here, and that you couldn't get it, that ASADA, for want of better words, couldn't get a conviction at that level, and that the level of CAS was here. So there's two different levels there. This is the Australian level that Australians all expect and deserve, and this is the CAS level in a court.
Well,
that's what you said.
Senator, this is consistent with your remark that the AFL Essendon players were treated the same as rapists. And with all due respect, we are talking about totally different situations. I've worked most of my life in the criminal jurisdiction, Senator. I've arrested and charged rapists on multiple times, and I can tell you it is totally different. What we are dealing here with is sports law. The sports law requires a bar which is called comfortable satisfaction, which is movable between balance of probabilities and beyond a reasonable doubt. Both myself and WADA believe in this case the AFL tribunal held that bar far too close to beyond a reasonable doubt.
But wasn't the AFL tribunal WADA compliant? When they set up the AFL doping tribunal, WADA was involved in the setting up of that process, were they not?
Not to my knowledge, sir.
So you're saying that the AFL doping tribunal was not WADA compliant?
No, I'm not saying that.
I'm just trying to understand, Mr McDevitt.
Well, Senator, there is a framework which starts with the UNESCO Convention, as you are aware, of which there are hundreds of countries which are signatories.
No. He's just finishing up and I'm going to send it back.
We then have, as you're aware, the World Anti-Doping Code. WADA does not own the code and WADA does not impose the code. All that WADA does is they monitor compliance with the code. The code itself is developed by countries and sports.
I understand that, Mr McDevitt. I'm just saying, was the AFL Doping Tribunal, the way it was set up, was it compliant with WADA or was it not? Do you know, yes or no? Well, fair enough if you don't know, but...
It was established under the AFL's anti-doping policy, and yes, the establishment of that tribunal is consistent with the requirements of the World Anti-Doping Code.
Right, so it was consistent. Okay, last question, Chair, thank you. Australia, Mr McDevitt, is a signatory to the International Labour Organisation Convention of the Rights of Workers and their conditions of work. Okay, now this specific treaty was ratified by the Australian government decades before anything was signed against doping in sport. Now, the fact of the matter is now here we have, what concerns me, Mr McDevitt, is that we have a code that you say the Australian government signed up to, which now a foreign body, entity, has affected people's right to work, their ability to work. Can you see my concern here, Mr McDevitt? A foreign body has taken away people's livelihoods. And I might also add to that, Mr McDevitt, that these people, some of these people have, you know, business interests outside of football, so when they retire, you know, they're looking to the future. And I know for a fact, Mr McDevitt, that some of these people have interests in business that are involved in other areas, and sports promotion for one, where that business has been told, Mr McDevitt, as a result of this foreign body that's not subject to scrutiny of the Australian public and Parliament, that they've been told, don't bother applying for work with us to promote our sports thing if you've got such and such, who's one of the Essendon 34 or players in that thing. Can you see the wide-ranging ramifications for individuals, Mr McDevitt, and how this is a very slippery slope to be going on? And I've got no truck with people, Mr McDevitt, who are drug cheats or cheat, but they should be trialled under Australian law where it's able to be scrutinised by this Parliament. Our job here is to protect the rights of Australians to a fair, transparent trial.
All right, Senator Madigan, you've made that point, so we'll finish the questioning there. I'll allow Mr McDevitt to respond to that, and then I'll move to Senator Back.
Senator, let me try to answer this as quick as I can. Let me read this to you. An ineligible player cannot participate in a training camp, exhibition or practice. The term activity also includes, for example, administrative activities such as serving as an official, director, officer, employee or volunteer of the organisation described. Ineligibility imposed in one sport shall also be recognised by other sports. Now, you probably think I'm reading something from Switzerland. I'm reading the AFL's rules, Senator. What you are seeing in place is the AFL applying its own rules, Senator. If people are found to be in breach of the AFL's anti-doping policies, there are very strict consequences. And what you are seeing now, and it is not forbidding employment in a whole range of other areas, but there are very, very specific rules, AFL rules, about where and when somebody who is actually undertaking a ban can be employed. And that's the AFL's rules, Senator.
But the AFL Doping Tribunal didn't find them guilty, did Mr McDevitt?
We're going to leave it there, Senator.
Cleared them, Mr McDevitt.
Senator Madigan, we're going to leave it there. There might be time to come back, but I've got others waiting. So, Senator Back.
Thanks, Chair. Mr McDevitt, I also want to ask some questions about Essendon and this thymosin beta-4. Can you tell me, were the players advised by the Essendon club of the supplement they were to be given?
My understanding, Senator, and obviously I wasn't there, obviously, and I can't put words in anybody's mouth. Suffice to say that 34 players have given statements and evidence to say that they attended briefings about the program that they were to enter into, and 34 players signed consent forms to be administered a number of substances, one of which was thymosin.
And do you know if they were told that that particular product was legal to be used?
Senator, there have been various accounts about exactly what players were or weren't told, and whilst I appreciate that this is a very important point about what information they were given, for example, by support personnel, ultimately the onus rests always on the individual. So, for example, if they were unsure, then they should have sought advice from their doctor. Their doctor gave evidence to say that none of them did. They should have gone to the website where you can actually look up the substances that are banned. We have no evidence that any of them did. So they didn't make the inquiries. Now,
well, that's not true. Sorry. I mean, one of the players did some research on the product. That's well documented.
Can I just continue? So,
sorry,
no, thank you, Senator Donatali. It's fine. The advice to me was that they did receive assurance in writing from the Essendon Football Club that the product they were to be given was legal. Can you respond to that, or can you take that on notice and advise the committee whether or not my assumption or the information available to me is accurate?
I'll take it on notice.
Now, could you also tell me, and again the advice to me is that not all players were actually given the supplement, that there was a number who were not given the supplement. Is that consistent with your understanding?
That's correct, Senator.
So, now, but they are amongst the 34 who have been found guilty, although they never were given the supplement.
Sorry, Senator. Let me just correct that.
Yes.
There are other players beyond the 34 who were not given injections.
Correct.
Our evidence is there were two threshold issues applying to the 34, which were quite critical. All 34 said they did receive injections of the players who we proceeded against, all 34, and all 34 did sign consent form for various substances, including thymosin.
Now, were they tested?
Yes, Senator, there were, I think, 30 testing missions across the 2012 season.
Of all 34?
No, Senator. The 30 testing missions covered a total of 21 players, and on all 30 testing missions, none of those 21 players ever declared receiving an injection from Mr. Dank.
So there were then 13 who were never tested. 21 out of 34 were, 13 were.
I'm not sure how many of the players, what the double up was. What I'm saying, Senator, is 21 of the 34 were tested.
So at what point, can I ask, did they actually identify to somebody that they had been given this supplement? Was it at the point of testing? Was it when they went in for a test? Can I ask you this? Was this the scenario? They went in for a test, the person about to test them said, have you been given any supplements? Is that how it happened?
That's how it happened, Senator. So they are asked the questions around what have you been given in terms of medications, supplements, any substances, vitamins, anything. What have you been given in the previous 7 days? And what we've had is not one of them declare these injections. And as I said earlier, their own doctor giving evidence to say none of them approached him in relation to these particular injections.
So we know that 21 were tested, but we know that 13 weren't tested. Is that correct? Am I right in that summary? You mentioned 21 out of 34.
21. Well, Senator, I'm not sure even out of the 21, so you're arriving at a number 13. Your number may actually be higher than that, because I'm not sure exactly how many times you know,
Well, perhaps
players
you
might
could
have
take it on
doubled up.
notice, because
Yeah.
the point I want to get to is that if there are numbers of players who were never tested and therefore were never asked, then the question to me is how are they now found guilty in the court when indeed they weren't tested? The second group, when you just mentioned to me the last 7 days, the information available to me is that amongst those who were tested, there were people who had not, in fact, taken the supplement or been given the supplement within that last 7 days, and yet they're in the 34. So my assumption is that we've got three groups. Those who were tested within the 7 days, said they hadn't been, they're guilty. Group 2 had not been given a supplement within 7 days, and therefore were absolutely honest when they said, we haven't been tested in the last 7 days, but they're in the guilty group. And then we seem to have a group that haven't been tested yet, and they're in the guilty group. I need to understand where you can have the guilt of 34 people,
So, Senator,
some of whom haven't been tested.
The premise of your question is that the offence itself is failing to declare the test. That's not the case.
Right, tell me where the offence was then.
The offence itself, the violation was established through numerous pieces of circumstantial evidence. And if we have the time, I'll step you through that, Senator. But what the failure to declare was evidence of was not it wasn't the offence in its own right, but what the CAS found was that the failure to declare on 30 separate missions to 21 players was indicative of the course of conduct and the culture of secrecy around this particular program. And Senator, to be frank, it wasn't a supplements program. This isn't supplements, this is banned substances.
Right,
This was an
I want to
injections
get to that.
regime,
So
not a supplements
you've
program.
again confirmed 21 players, so there are 13 at the moment who have been found guilty in my mind without having been the subject of testing. Can I ask you, what effect does this... No, let me ask you first, how many, if any, positive results, swabs, I'll call them swabs from my experience as an equine veterinarian, how many swabs were found to be positive?
Senator, there is, at this point in time, there is no test to detect artificially administered thymosin beta-4. So it occurs naturally in all of us.
That was going to be my next question. What are the blood levels naturally occurring so we can know the levels of artificial injection?
It occurs naturally in all of us to various extents.
Exactly, yep.
So much as there are efforts underway, as with a whole range of substances, to develop tests, in 2012 there wasn't a test for detecting artificially administered or exogenous thymosin beta-4. To date, there still isn't. So the fact that there wasn't a positive test is of itself not really taking us anywhere. And this is why, in this case, the case was established via other evidence, other circumstantial evidence, because there wasn't positive test.
So do we know what effect this or other supplements have? Do they have a stimulatory effect on the central nervous system? Is there a metabolic stimulation? Does it enhance the oxygenation of the blood? What do these supplements do? I mean, how do we know they weren't placebos? How do we know they weren't just coloured lolly water?
Well, Senator, the most interesting thing about all that is the question you ask is so important, because that's why it's so dangerous, because we don't know what the effects are of these substances. We know that people use TB4 for things like accelerated recovery, and that's why we find athletes actually utilising substances like this. But, you know, you've hit the point. The scariest thing about all of this is we actually don't know. There haven't been human trials on this substance. So that's why it's banned.
We don't know what the naturally occurring blood level is, therefore we don't know what the impact is on blood levels of artificially injected material. It doesn't, as you say, it may have a recovery effect, and I can understand that, but it doesn't seem to have an effect on performance on the day. And I agree with you, Mr McDevitt, I agree with you about the abuse of drugs, pharmaceuticals in the body, whether it's an animal or whether it's a human being. But the concern I have is this, that you mentioned in your response to Senator Madigan that the Court of Arbitration of Sport found that no records had been kept by Essendon. I have no difficulty at all in a circumstance in which somebody finds Essendon guilty of a whole range of activities. But we've learnt from you, I think, that there is not a jurisdiction within Australia, a court of appeal within Australia to which these people can appeal. That's correct. It's the Court of Arbitration of Sport. I understand there's one in Sydney, but I'm correct in that assumption, yes?
All parties would have had an appeal to the AFL Anti-Doping Appeals Tribunal.
Right, which they did.
If beyond that, the appeal option is to the Court of Arbitration for Sport. And Senator, can I just add, that is not unique to the AFL. That is the case for all 85
Sure, but can I ask, when Mr McDevitt did, presumably the Australian Parliament or the government, make a decision to allow a circumstance in which an Australian court ceased to be the highest court of appeal and it was passed over to a Court of Arbitration of Sport. When did that happen? And what was the process that allowed it to happen?
Senator, I can't give you the exact date off the top of my head, but what I can say to you is that decision was made when, in the Australian Parliament, when Australia committed to becoming one of the hundreds of countries who were a signatory to the UNESCO Convention on Anti-Doping. Now then, underneath that, you had a whole series of articles and legislation and regulations to give effect to that commitment by the Australian Parliament.
Thank you.
So I guess it was when the ASADA Act of 2006 was passed through the Parliament. Right. That is probably the when time. This all Thank you.
Now it is the case, isn't it, that in the team sports in the United States, football, basketball, baseball are not signatories to this particular contract.
That's correct, Senator.
Okay, now have you gone yourself to understand why those codes, team sport codes in the United States, are not signatories?
Yes.
And do you think that is of any relevance to this country?
Senator, it's a really good question. Let me just talk about the National Football League for a second. So the National Football League is not, as you say, a WADA, technically WADA compliant organisation.
I'll finish up.
The NFL works out its rules between the Players Association and the NFL players themselves. So they work out the rules. Let me give you an example. Human growth hormones, which has been on the World Anti-Doping Code banned list for multiple years, was not actually even banned in the NFL until the end of 2014. Why, Senator? Because the NFL players decided that they didn't want it to be on the banned list. And then, Senator, when they did actually say, yeah, well, okay, we'll accept that that's on the banned list, they determined their penalties. Their penalty for use of human growth hormone in the NFL is a 4-week ban. Under the World Anti-Doping Code, it is a 4-year ban.
Right, okay.
So what you've got over there is frameworks where the sport organises their own. Senator, what you've got is a Clayton's framework when you don't want to sign up to the World.
I think your advice to me, and I wouldn't dispute it, is that their circumstance isn't applicable here. I do want to sum up this way, though, if I can, Mr McDevitt. It seems to me that there are 34 people who are now found guilty, with the implications of it being banned from sport promotions, etc. A number of them, I think it's 13 from the numbers you've given us, a number of them were never tested. Another group were tested, as I understand it, but outside a 7-day preclusion period, and they have been found guilty. A third group would appear to be within the 7 days and they are guilty, but we have a circumstance in which the blood tests, or if they were blood tests, the tests themselves are inconclusive because nobody knows what the baseline is from naturally occurring chemical in the body. We don't know whether these particular chemicals have a direct effect on performance on the football field, and we are in a circumstance in which, as you have said, a football club had no records. A group of players, some of whom it would appear, at least one of whom, did avail themselves of the opportunity to learn more about the pharmacology. But I would put to you the view that an 18 or 19-year-old kid, if told by the club A, that the product was safe, B, that it was legal, C, with or without their parents or other guardians, were advised by the club in writing that the product was legal to use, then I am at a loss to understand how 34 players are now guilty, and I am also at a loss, and I'll finish here, in terms of proportionality. Even if the case can be made, and I don't believe it can, the proportionality of a group who said, yes, we've been taking this stuff within a 7-day period, and another group who did not take it within the 7-day period, so therefore would have been quite honest in saying, no, we didn't, and a third group who never took it or were never tested, so therefore we really don't know whether, all three have been found equally guilty. And I just find that to be unacceptable as an Australian. Thank you, Chair.
Senator,
if you could comment, I'd be appreciative.
Thank you, Senator. The members of the club implemented a program to make Essendon players bigger and stronger and able to recover more quickly to gain an advantage over their opposition. In the words of Stephen Dank, thymosin was the vital cornerstone of that team-based program. Essendon sports scientist Stephen Dank was shown to have used thymosin beta-4 on other athletes prior to him getting to Essendon. There were over 100 text messages that unveiled a plan to source thymosin beta-4 for the purpose of doping the Essendon team. The players signed consent forms agreeing to thymosin injections, 34 of them, and each admitted to receiving a number of injections. 6 players reported being told they were being injected with thymosin. 2 players reported seeing vials marked with the word thymosin in the sports scientist's fridge. 2 players sent text messages discussing their thymosin injections with Stephen Dank. Analysis of the substance compounded by the pharmacist showed that the substance was no other kind of thymosin, with a 97 to 99% probability other than thymosin beta-4. So there was no, this stuff about thymomodulin or the good thymosin, quite frankly, was shown to be absolute rubbish. That is a very short synopsis of some of the evidence that was presented. Now, I know you are very focused on the test, but again, I just need to say to you that the CAS did not convict or find guilty these players purely because they hadn't, sort of declared something on a test. What they did look at that aspect was simply to say that that was consistent with the other facts that led them to believe that this was a program which the players had agreed to keep secret. A program which the players as a collective group agreed was taking them right to the edge.
And one argument could have been it was the code of the team. Another argument has been they've been guilty of trying to hide information. Thank you for your answers, but as I say, the proportionality, Mr McDevitt, is the thing that really gets to me. The proportionality, I think, is grossly unjust. Thank you, Chair.
Thank you, Senator Back. Senator Di Natale.
Mr McDevitt, I'm not sure which one it is, because a moment ago you told us you didn't know what this stuff does, and now you're saying it makes the players bigger and stronger. Which one is it?
Well, Senator, don't forget there were multiple substances here.
Yeah, but they're not. That's irrelevant because they're not found guilty of taking other substances. They're found guilty of thymosin beta-4. So what does it do? Does it make people bigger and stronger, or we don't know what it does?
Well, as I said earlier, we don't know exactly everything that it does. It is primarily promoted, in my understanding, for recovery. As being an agent for recovery.
Just again, to be clear, you're saying it, one hand it makes people bigger and stronger, then we're talking about recovery, and then we're saying we don't know what it does. Isn't it fair to say there's a good chance this stuff does nothing for performance?
I doubt it. Senator, let me just...
No. What's the evidence that it does?
Senator, if you can recover more quickly, you can start pumping iron, you can start running. So
what's the fact that you can train harder, Senator,
so if you recover more quickly, yes, you can get bigger and stronger.
What's the evidence that it improves recovery?
Well, Senator, I'll have to take that on notice. What I can say to you
so you're making claims.
Well, Senator,
you're making claims about what effect this.
Well, Senator, it is promoted globally, and it is distributed and trafficked globally because it is believed that it promotes recovery. And as I said to you, if you can recover more quickly, you can train harder, you can get bigger and stronger. And that was the aim.
Go to any health food shop. There are lots of drugs there that are promoted as helping you to lose weight. You know, you lose 5 kilos in a week. It doesn't mean that's what they do. I'm asking you about the evidence for what this does. The reason I'm asking you is because I think you call this the worst case of systematic doping or team doping this country's ever seen. I mean, how can you put a substance like this, which, I mean, some people argue does absolutely nothing, next to a drug like EPO or testosterone or growth hormone, which are all deliberately designed to help people become bigger and stronger?
Senator, it is a banned...
Okay,
it's a banned substance.
I saw Mr. Bowles pass you that. Well, I'm trying to get you on the facts here, and the facts are that you're making claims about the drug that are completely unsubstantiated.
Senator...
I accept that it's a banned substance, so let's move on to that. Let's move on to that issue. What's been the total cost of Operation Cobia to date?
Total cost of the Cobia investigation has been $5.947 million. External legal costs were $4.329 million. Costs arising from the federal court cases and appeals by Mr Hurd and the Essendon Football Club totalled $1.86 million. They're all included in the 5.9, okay. And $1.26 million of that costs have been recovered from Essendon and Mr Hurd when they had costs orders against them.
How much did ASADA contribute to WADA's costs, of preparing a appeal?
For the WADA appeal, the costs were in the order of $130,000 and a $10,000 cost for the CAS arbitration fee. Ultimately, the CAS costs themselves were to be paid by Essendon and the AFL, not by ASADA. And I hasten to add, Senator, that the costs of the CAS appeal and the CAS hearing were significantly less than the costs of the original AFL tribunal hearing.
Okay.
Significantly less.
Do you have those numbers?
Okay.
950.
Yes.
Yeah, approximately $950,000.
Compared to?
$130,000.
Okay. What I'm interested in is there was clear change in sort of response from you, Mr McDevitt. You back in sort of middle 2014, the impression was that the players weren't at fault. I think you went well. Perhaps you didn't go that far, but I think it's best if I quote you. In 2014, June, during a radio interview, you said, I think what you're looking at here is a case where there would be a good opportunity for a player to say no significant fault. And then I think in November again, you went on and said that based on the information that ASADA has, a maximum reduction of 50% of the applicable period of ineligibility for no significant fault or negligence would be appropriate. So you were at that, clearly of that view, and then something changed, and then it became, as I said, the worst case of team-based doping in the country, and the players had a head in the sand approach. What changed?
A number of things, Senator. So, firstly, let me just say firstly in terms of penalties, very important to point out that ASADA does not determine the penalties.
No,
penalties are determined by the sport themselves, or if it goes to a tribunal, by the tribunal. So in relation to the Essendon players, discussions on penalties were had with relevant parties in June 2014 and in November 2014. And Senator, I engaged in those discussions with a view to trying to get some resolution on these matters. That was what I was trying to do. Now, and I tried to do that before infraction notices were issued. So the reason I did that was there were opportunities for players, or, you know, it's the same with any athlete, to come forward, for example, and claim substantial assistance if they come forward and give assistance, or if they decide that they want to mount a defence of no significant fault, for example. Now, Senator, and this is where it becomes important, in this case, to actually claim no significant fault, and I did put it out there and said, look, you may be able to try to establish this claim of no significant fault. The players said, no, we're not going to try that, we're going to fight it. Now, and what we're going to do is deny it. Now, to get no significant fault, Senator, you have to firstly admit that, yes, you had the substance. So once they made that critical choice to go to a hearing, the onus was then on them to be able to prove no significant fault. But they stayed in a state of denial, and hence, Senator... But
maybe they believe they were actually weren't taking a substance.
Well, Senator...
And that's the whole point of the no significant fault.
Yeah, so
it's a non sequitur.
But, well, Senator, to claim no significant fault means I had the substance. I drank this glass of water, and yes, there was a banned substance in there, but I didn't know, you know, it was put in there by someone else or whatever. But I have to first say, yes, I took that water, and yes, I accept
Right, so you're saying they rejected having any substance at all?
They rejected it, Senator.
Right, okay.
Yes.
And once then it was established that, or they acknowledged that they were injected with the substance, but they weren't, they made it clear that they had no knowledge that this was a banned substance. Why is no significant fault still not appropriate in those circumstances?
Senator, they said that they were injected with thymosin.
Right.
But
they're not chemists. These are kids. They're 9-year-old kids.
Well, Senator, they're not kids. Let's just put that. Right. You know, they're not minors. Right. They're not children. Yep. They're full-grown adults. Yeah. They're full-grown adults who receive education on multiple occasions.
Well, most doctors don't know what thymosin is. How do you expect a young footballer to know what Senator, it is?
Their education is about personal responsibility for what goes into.
You know, but we're getting back to the no significant fault issue. I get that, but what my issue is this is, and it's similar to Senator Bax in a way, is that these are young players. They don't understand pharmacology. As I said, this stuff is a lot of it's hocus pocus, but they don't understand pharmacology. They're given a reassurance. You're saying early on no significant fault, and then something changes where you throw the book at them.
Senator, hang on. When you say I said no significant fault, I said to them
that it would be appropriate.
No, I said to them, if that was the case, I said to them, come forward and tell us fully what did happen, and if you can establish no significant fault, then that would lead to a reduction in their penalties. I mean, if they had all the questions, why didn't they go to the doctor?
There are others outside the 34, Mr. McDevitt. They're laughing their heads off.
Why wouldn't you ask the doctor? I mean, you said they don't know about pharmacology, so if they don't know about pharmacology...
I mean, these are young people in a professional sporting environment being given something that they're told is going to help their performance. Right. They're being told by... I mean, you quote Stephen Dank as an expert in terms of what this stuff does. They're in a sporting environment with a whole sports science department behind them. They're being given information saying this stuff's legitimate. Why on earth would you go to the doctor? I don't understand. It doesn't follow.
Well, sorry, why didn't they go to the doctor?
No, you're saying why didn't they go to the doctor?
The doctor
why should they?
The doctor was their personal... Well, Senator, would you let someone come up and give you multiple injections and say, don't worry, it's all good?
If I was a 20-year-old, getting my dream job with the sports science department behind me and a coach saying, look, this is absolutely fine, it's all legitimate, it's by the book, why would I go to the doctor?
Sorry?
I mean, that's a ridiculous proposition. Most people go to the doctor when they have an injury, when they're unwell. We've got the sports science department giving them supplements. That's not a trigger to go to the doctor.
The sports science department, Stephen Dank.
But we didn't know about him at the time.
Well, yeah, I mean, this is all well and good in retrospect. And the issue, Mr. McDevitt, I know this sounds like it's a personal attack. I get that you have to implement what is a very rigid code. But again, with Senator Back's, I'm of a similar view that you say ultimate liability rests with the players. Do you actually think it's fair?
Yes, I do.
Do you think it's fair?
And the reason I think it's fair, Senator, it is fair to all of those thousands of athletes in hundreds of sports who run onto the field and expect it to be a level playing field and do not want to run onto the field with somebody else who's got substances pumping around in their body that are promoted for quick recovery
that they don't know are actually prohibited substances.
Senator,
so I mean, let's not forget that small detail.
Senator, it's their job as athletes, as professional athletes, to make it their business to know, and that is the cornerstone of the code. And it's there for good reason, Senator. And yes, it might be seen to be strict, but it's strict and absolute. And you ask any professional athlete anywhere on the globe, that's why this is so heavily subscribed across the world. Athletes want to be in a fair, square sport. So the athlete, if the athlete gets injections, the athlete must be asking questions about what is it that you are injecting into me.
Let me ask you just a couple more questions. One of the things that's, again, struck me as a gross inconsistency here is you've got one tribunal that uses a particular standard of evidence, then you've got another tribunal that uses a totally different standard of evidence. So we're talking, for example, I think it was described as chain versus strand, but basically a different standard of evidence and proof. Why do we have that? Isn't that a problem with the process?
No. Senator, the standard of evidence was the same for the tribunal and for CAS, and is the same for all sporting tribunals. And the standard is comfortable satisfaction. And as I said, the comfortable satisfaction bar can move from...
Are you saying that they've got the same...
I'm saying it's same standard, yes, but it's up to the panel adjudicating to apply that bar correctly and appropriately in the case. Now, so what's happened here, they've started with the same standard of proof, but WADA and I both felt that it had not been applied correctly by the AFL tribunal, and
so
the Court of Arbitration for Sport also believed
but that's different to the analysis that I've seen. So you're just saying the AFL tribunal got it wrong, but they're using exactly the same process for determining guilt.
Well, there's a couple of different issues that you brought in there, Senator. One is the standard of proof to be applied, so almost the lens that the adjudicators should look through. That is the comfortable satisfaction lens, which was applied by both panels, but set differently.
Well, hang on. Applied by both panels, but set differently. Okay. That's a different process.
Well, see, Senator, this is where it is slightly complicated because, let me just try to sort of explain a little bit. If you were to say, for example, that something is adjudicated beyond a reasonable doubt, it means that you are saying probably with 95 to 98% certainty this is what happened. If you are saying on the balance of probabilities, you are saying this is about a 60% possibility that this happened. Now, the difficult thing with comfortable satisfaction is it actually moves in between those depending on several factors, including likely penalties, severity of the offence, and so on. So that was, if you like, the level of accountability that both panels were expected to apply in this case. The other factor that is slightly confusing is on the way the evidence is presented, and that is this sort of links in the chain versus the strands in the cable approach, and I don't want to get too bogged down, but I gave an example earlier. The tribunal used the links in the chain approach and said you must prove where the thymosin beta-4 came from. Now, the Court of Arbitration for Sport said that's wrong. That's wrong. You don't have to prove that at all. And in fact, if you had to prove that in every anti-doping case, it'd be almost impossible.
So without getting, why the difference? Why the difference between the two?
Well, Senator. I mean, look. The other way of looking at this is there are as you know, in every walk of life, whether it's a criminal jurisdiction, commercial courts, international courts, whatever. Quite often, you will get different panels.
Yes,
looking at the same evidence through presumably the same lens and coming up with very different conclusions.
We're not describing that. You've already said that there are different thresholds applied. So we're not talking about that. We're talking about different thresholds.
No, we're talking about comfortable satisfaction.
You just said one's 60%, one's 80 or 90%.
No, sorry, I said that there are two other thresholds, balance of probabilities and beyond a reasonable doubt. So the criminal jurisdiction uses beyond a reasonable doubt. Sports use comfortable satisfaction. I didn't invent it, but it moves in between those two.
Look, let me just finish with one or two last final questions. I want to ask about the Cronulla players. Why hasn't the NRL issued infraction notices to those 5 former Cronulla players who declined to plead guilty in 2014?
Senator, I've asked the NRL the same question.
Okay, all right, so that's a question for the NRL. And let me ask you about taking no action against the 4 Essendon players who signed the consent forms to be administered with thymosin beta-4, but then said they didn't receive injections from Dank in 2012.
They weren't proceeded against.
Why not?
Because they had not. This was about gathering sufficient evidence to be able to proceed.
So they were just smart by saying they didn't get the injection?
Well, Senator, can I answer this? Senator, this is Ellen Purdy-Kogianis from ASADA. Those players did not disclose that they had no injections, and there was no evidence to the contrary.
Right, so they may have had the injections, you just didn't have evidence to support that, whereas you had evidence that others did.
That's right.
Okay, all right, got it. Thank you.
Thanks, Senator.
Can I ask a couple more questions? So these people self-incriminated, that's what you're telling us. The people who were found guilty self-incriminated. The ones who were let off, I think you said they had received injections, but what? I'm at a loss to understand the difference between them.
Sorry, they had signed consent forms, but denied receiving injections.
Right.
And there was no other contemporaneous evidence, either in the text messages or material gathered from Essendon's server, that indicated anything to the contrary.
So the message for the 34 was they should have gone down the path of their colleagues, shouldn't they? You wouldn't be here today and they wouldn't be guilty today if they had not self-incriminated. Am I correct in that assumption?
I wouldn't. I wouldn't assume that, Senator. What happened here was there's 2 issues. Was there a possible violation, and does it warrant action? There was an evidence gathering exercise which included multiple elements, including players' interviews, but also other parts. And we proceeded against the 34, where we felt that we had sufficient evidence to proceed, and subsequently that decision has been confirmed and validated by the Court of Arbitration.
Can I just follow on one last question, and I'll tell you what I'm on, but are you on any pharmaceuticals at all?
No.
You're not on any?
No.
I am. I'm on Ramapril, Caduet and Cartier. And I've got to say to you, I'm a veterinarian. I'm on those pharmaceuticals as a result of advice from my doctor. The chemist prescribes them. I have never gone to have a look at the pharmacology of those 3. I trust the advice of my doctor and my chemist. I'm at a loss to understand how you would say that an 18-year-old... I spoke recently to John Worsfold, who was the Eagles coach, now the Essendon coach, a pharmacist. And I put to him the question, would an 18-year-old kid in the Eagles have challenged you, John, if you'd said this is okay to use? You're my senior coach and you happen to be a pharmacist. I'm at a loss to understand how you would think that an 18 or 19-year-old would go past the doctor, the pharmacist, having got something in writing from his club, presumably signed by the doctor to say it was legal to use.
This is the problem, Senator. In your situation, those medications were, you just said, given to you by the doctor.
Yep.
That's not the case here, Senator.
But the doctor
That's not
oversaw
the
it,
case
didn't
at
he?
all. Senator,
The club doctor oversaw it, Mr.
No,
McDermott.
Senator, the club doctor was kept totally in the dark. That's the difference between your situation and this. Why was the club doctor kept totally in the dark? I know you wouldn't take anything probably if it wasn't given to you, as you just
Correct.
said, by your doctor. Well, in this case, the doctor was kept in the dark and this was not given to them by the doctor.
So in terms of this particular brew, which you think probably aids to recovery, you know, Gatorade shouldn't be used? Helps in recovery?
Well, Senator,
Water,
Gatorade,
rehydration?
Gatorade's not on the banned list. And
But was this?
This was. This Thymosin
At the
beta-4
time?
is on the banned
Was it
list.
then?
Yes. And, you know, if athletes, you would not believe the education, the level of education that is delivered to these people by the AFL and by us constantly and regularly about their personal responsibility. And look, I know people talk about, well, the club said to do it or someone else said to do it. You just cannot shift that personal responsibility to anybody, full stop.
And to finish someone's career is appropriate in terms of a penalty?
That education program tells them very, very clearly, Senator, what the penalties are. And there are significant consequences for going down this path for very, very good reason. I mean, if you have players running onto the field and playing against 17 other teams, I mean, what do you say to the other 17 teams?
And
about a team that has embarked on a program designed to make them bigger, stronger, and recover more quickly.
The difference is, and you can speak about Olympic sports, etc., is that athletes are drug tested. If there's a positive, the sample is split to an A and a B. If the A sample is found to be positive, the due process requires that they're advised. The B sample is either analysed by a separate laboratory, or more likely, they get the chance to nominate someone to oversee it. So in all of those cases, you've got the due process of the law, haven't you? You've got a drug, a chemical, call it whatever you like, that is known to have a performance-enhancing effect, and it has been found to be in the body, and nobody can argue the guilt of that person. But this is a totally different circumstance,
Senator,
isn't it?
What you've said, and you've described very well the processes for an adverse analytical finding.
Correct.
You have described that beautifully. That's exactly what happens when there is a positive test.
That's right.
So
we're not dealing with that here, are we?
So, Senator, you know, we've averaged 2 positive tests per month roughly for the last 5 years in this country.
Yeah.
But what we've also got is more than 30% of our cases have been where there hasn't been a positive test. And Senator, the issue with a lot of these substances now is that there are masking agents. The substances exit the body very, very quickly, and so that's why testing needs to be.
We all know
much
the
more
challenges
focused.
of getting a positive test.
What I'm saying here, Senator, is the lack of a positive test in no way, shape or form means that an athlete is not cheating.
Sure.
That's what I'm saying.
With respect, and I'll finish there, and I am sounding cynical, but I do have to say to you, I think the reason you went down the path of WADA rather than an Australian Court of Appeal, based on many, many years of experience in this space, is that I think you realise that an Australian Court of Appeal would have upheld the AFL decision. You don't have to comment on that, it's just my observation. And it might appear cynical, but I think it's the
I
case.
disagree, but in the interest of time.
Okay, thanks. Thanks, Stu.
Can I ask one quick one, just for clarification? Thymosin beta-4, you said it's on the banned list. Why is it on the banned list? Is it because it hasn't been tested, or is it because it's known to be performance enhancing and unsafe?
Senator, I'd have to take it on notice. I suspect it will be a combination of both. Okay. I suspect it will be because it hasn't gone through the clinical trial, so it hasn't been determined to be fit for human consumption on the one hand, and it has also most likely indicated that it does enhance performance in terms of the early science. And I suspect that for those two reasons, it's probably been put on the banned list, but I'll come back to you if that's wrong.
And what's the tipping point with performance enhancing? Because there are obviously some things there are a lot of things that are performance enhancing, but they're not all on the banned list. So, natural substances, all sorts of things which help you perform better, help you recover better. Is it safety, or is it how much it helps your performance?
Again, Senator, it's a combination of both. So what happens with the banned list, my understanding is it is released annually, the list. It is updated. There is a team of scientific experts who are brought together globally, and they assess, because obviously hundreds and hundreds of pharmaceuticals and other substances come onto the market each year. They assessed, and the list is updated, and then the list is promulgated annually. That's how it works.
If I may elaborate on that,
Please.
the list committee the WADA's list committee considers 3 criteria when deciding whether or not to include a substance on the prohibited list. Those are whether the substance is performance enhancing, whether the substance is dangerous to the health of athletes, or whether the substance is against the spirit of sport. And if the substance meets 2 of those 3 criteria, then it's a substance that the list committee might resolve to put on the list. As Mr McDevitt said, substances that have not been approved for human use or veterinary use are prohibited. They're in what's known as the S0 category. Thymosin beta-4 is a substance that is regarded as being one of those sort of peptide hormones, and it is said to cause cell regeneration and blood vessel regeneration. But as Mr McDevitt said, we can give more on notice.
Just on that though, so you said it needs to meet 2 of those 3 criteria. So a substance could be safe, but if it's performance enhancing and it's against the spirit of sport, it could be on the banned list. That seems a slightly nebulous term. What does that mean, against the spirit of sport? Gatorade clearly isn't against the spirit of sport. It's seen as safe, perhaps slightly performance enhancing. Is it the degree to which it's performance enhancing that determines whether it's against the spirit of sport?
Well, the spirit of sport is about fair play and an equal field and a level playing field, and everybody, no athlete having an advantage. So to be in breach of the spirit of sport means that somebody has got an artificially induced advantage.
So potentially a masking agent might be a substance that masks the evidence of a performance enhancing substance in the body. That's not a substance that of itself might be performance enhancing, but it would be against the spirit of sport because it was concealing the use of a performance enhancing substance.
Yeah, okay. We're just about out of time, but Senator Madigan, did you have anything further? Yes. Oh, sorry. Yeah. Sorry, my apologies. You haven't got my attention. So, Senator Peris.
Yeah. So, Mr. McDevitt. I just wanted to go back a few steps. So, in February 13, thymosin beta-34, was that on the ASADA ban list?
Senator, it's not the ASADA banned list, the WADA banned list.
Yeah. But it wasn't. Was it on the ASADA ban list or WADA ban list?
We don't have our own list, Senator. We
go under the...
We all use the one list,
okay.
And it is, it's brought together. Experts look at it each year, and it's put out, and all subscribing countries and sports use the one list.
Okay.
Other than, for example, the NFL, like we discussed before.
Okay.
They make their own list.
And that came into play in 2006. Is that what you said?
I'd have to double check the WADA itself. I think the first iteration of the code came out in 2003. Our legislation was passed in 2006. I'm not sure. I'd have to take on notice when the list itself was first brought about.
So Senator, there have been lists around since the IOC, for instance, had a list of prohibited substances and methods. The first WADA list, I believe, was in 2003. ASADA, we applied the WADA list, so that gets distributed, published every year by the World Anti-Doping Agency, and that's the list we apply.
Okay. A few things have changed, I guess, when I was back in my day as an athlete. I was drug tested by ASADA and a WADA depending on my world ranking. So what you're saying is all sports in this country is subjected to WADA drug testing?
85. We have 85 sports, Senator. It won't be all sports. I think there are some sports who are not compliant.
Yep. And so who determines the sports that's not compliant to that?
The sports themselves actually determine whether or not they want to apply to be part of this framework and to have a compliant anti-doping policy.
Okay.
Because, of course, most sports want their sport to be clean and fair.
Yeah. So if it's a world anti-doping, should it... Do you agree that you should be an international sport to apply to that, or you're saying have a blanket approach for all sports?
Well, again, Senator, I'll come back to it's up to the sport administrators, how they feel about having a level playing field for their sport.
Okay. So the positive tests that came back, how many of those actually tested positive?
Senator, I said earlier that there is no, at this point in time, there is no test for detecting artificial thymosin beta-4.
Okay.
So there's no test itself at this point in time.
But it is on the banned substance?
It is on the banned list, yes.
Okay, and it has...
Well, when I say where it gets a little bit confusing is that we all have thymosin beta-4 in our bodies anyway. So when I say there's no test, we can't at this point in time differentiate between the endogenous TB4 which we all produce and that additional TB4 which might be artificially administered. So that's the test that's missing at the moment.
Okay, so you're saying that we have that naturally occurring in our body. I guess the point I'm sort of making, there was a lot of commentary about, no one went to the doctor. To me, coming from my sporting background, I'd go to see our team doctor if I was sick. But you have a sports science unit. I know that having ice baths, for example, helps with your recovery. Protein shakes, as we know, can contain amino acids which help with recovery, and athletes are provided protein shakes through their sports science unit. So if you're a player, excited about playing AFL, that's your dream job, and you're going through, and if you're told that this substance is naturally occurring, but to help with your recovery, you're taking a natural substance that occurs in your body only. So I guess it's a do you not agree that it's a harsh penalty?
Senator, can I ask you, did you, in your career, did you get injections on multiple occasions?
Well, we did when we went to India. We went overseas, so we'd all have to line up, and the team doctor would come along and give us our flu injections.
Okay, so it was, and it was explained to you that it was a flu injection, and was it administered by a doctor or a trained professional?
Well, the flu injection was administered by, yes.
Yeah, so you would have had the comfort and knowledge, and you would have done the personal research, knowing your responsibilities about what was going into your body as a professional athlete. So you would have asked the questions. You would have said, so this is the flu injection, and presumably it would have said that, and someone would have told you that, and you would have been comfortable that what you were getting was for the flu.
That's correct, right. And I guess what I'm saying that also, I mean, they were in an environment where they were told, what they were doing was the right thing to do.
And, well, Senator, they were told not to tell anybody. Like when you're an athlete, were you ever told, hey, don't tell anybody what these injections you're going to get, just don't tell anybody about that. Were you ever told anything like that? Would that have worried you?
No, I'm just trying to find out who the senator is here being questioned here. But, I mean... Fair point. Yeah, anyhow. But anyhow, I don't have any... I do. So I guess the only couple of questions I wanted to say does ASADA believe that the current anti-doping framework in Australia Do you think it's working well enough to cater for the AFL and other team sports?
Absolutely.
Okay.
All right. Did you have anything further, Senator Madigan?
Thank you, Chair. Mr McDevitt, you refer to this WADA list of banned substances. I've been trying to find where this list is. For the benefit of the committee, could you point us to where this list is? Because I'm having difficulty finding this list that you've referred to tonight.
I'll give you the link, Senator.
Right, and also for the benefit of the committee, between 2010 and the present day, could you, as ASADA, able to furnish the committee with screenshots of the banned substances over the past 5 years?
Well, essentially that will be copies of the lists. Yeah, I think we can get that for you. Yeah.
Right, and also where we can get those ourselves. Okay.
Sorry,
the committee can access
on the WADA site, which is all
to
part of the
present
education
day,
program that
the
goes to all
banned
the athletes.
substances.
So they all get education programs showing them exactly where the list is, but we'll make it available to you, Senator.
Right, thank you, Chair.
All right. Sure.
One final question. Does James have any further appeal rights over the ASADA matter?
Senator James Hird, as you know, initiated action against ASADA to the federal court, asserting that the investigation was flawed and illegal. The investigation was held by Judge Middleton to be entirely legal and lawful and appropriate. Mr Hird then exercised another appeal opportunity or right to go to the full bench of the federal court, and then we then had a unanimous finding by the full bench confirming the earlier finding. So he has exercised a number of appeal rights in this matter already.
Wait, but does he have any further? Or?
Well, Senator, I don't know what you mean to appeal what. He hasn't had a violation.
Okay.
I
was just a question. That was the straight. Yeah. Does he have any further rights? But I guess.
Well, as I say, he's exercised quite a few appeal rights, and you know, we talk about how long this thing's gone for. That's one of the contributing factors.
Mr Hird could have sought special leave to appeal to the High Court against the ruling of the full federal court, but he elected not to do that.
Okay.
Just a final one from Senator Madigan.
Back to my earlier question, Mr McDevitt, could you show us where that TB4 is specifically mentioned on those lists of WADA?
Yep.
From 2010 to the present day.
We'll take that on notice.
Thank you. Thanks, Chair.
And just before we finish, just a reminder for senators that written questions on notice should be provided to the Secretariat by close of business Friday, 4th of March 2016. Thank you, Minister. Thank you, Mr Bowles and Mr McDevitt and all our officials. We are now adjourned.